Good afternoon, everyone. Thank you to our end of semester Law Tech Talk. Today, we are very honored and privileged to have Professor Han-Wei Liu to join us. Welcome, Professor Liu, to Hong Kong, and also back to Asia. That Professor Liu originally was from Taiwan, and he then was a senior lecturer at Monash University, and now he moves to join SMU in Singapore. And so today, Dr. Liu will talk about a very interesting topic about international law and content governance. Dr. Liu is a very prolific scholar. His publications included one at this very prestigious International and Comparative Law Quarterly, and he has two forthcoming books coming. One was Cambridge University Press, and the other was Oxford Hart Publishing. And without further ado, I pass the time to Professor Liu.
Thank you very much, and it's my great pleasure to be back in Asia and especially back in Hong Kong. And I last time I visited Hong Kong is about 2003, so it's almost 20 years since I traveled around the world, and I really miss Hong Kong because I was born in the golden age where I really love lots of Hong Kong, like movies and scenes and singers, and yes. So today I'm going to talk about the. Thank you. So my topic, I guess when you first look at the topic of my presentations, you may be puzzled. What's the relevance? What's the connection between international trade agreements and content governance? And to be honest, I'm puzzled about the connections well, till I saw some of the provisions inserted by Americans a few years ago. And to begin, I just give you a bit of background about myself and how I understand the interaction between international trade law and comparative law, because as I can see from international trade literature, we are quite disconnected with like privacy law scholars, data protection law scholars, and it is particularly the case that for the past like more than 10 years, under the leadership of the U.S., we have been talking about we should promote free data flow, and we should prohibit data localization, and we should prohibit the forced technology transfer and the transfer of source code, etc. So a lot of new issues have been brought into international trade law. One of the reasons is that they often talk about it's a good idea to harmonize the law through international trade agreement. So if we look at from international trade law perspective, as I start as a PhD student, I pretty much took as a granted, and I think it's really a good thing, and we should promote harmonization, convergence. But when I continue my research academic journey, and I realized that it's not something that we really want to, especially when I spend time in different jurisdictions, I realized that different jurisdictions, they have different social, economic, and political contexts, that they have their local need and to respond to their local demands. So it's not always makes sense to harmonize things, and especially it's not always makes sense to harmonize in the name of free trade. So my research has been focusing on the intersection between international trade law and the new issues, especially when it comes to the data governance issues. And my argument or my overall theme is always be a bit skeptical and to think about what these provisions really, what's the real purpose behind these provisions, what Americans they want So this is the idea of my research project. I try to figure out the role of international trade law in promoting or safeguarding free speech. And my argument is that free trade and the free speech, essentially, there are two things. And I don't think it's a good idea to protect free speech through international trade agreements, and I will explain why. And so let me first start with a very old case back in about more than 10 years ago. This is a China audiovisual case in WTO. That's in the first decade when China just joined WTO. And one of the measures that China was challenged by Americans is that China has agreed to open up its market through its accession protocol, saying that within 5 years after China joined WTO, we should treat SOE, like state-owned enterprise, and foreign enterprise equally. So whatever the trading rights I give to SOE, I must do the same to foreign enterprises. And then one issue and one sector that has been challenged is the publication sector, because the Chinese government only gave the right of trading, including the import of foreign publications and the distribution of the publications solely to SOE. And the Americans challenge that, okay, you violate like your commitments under the accession protocol, and you also violate your commitments under the WTO GATT agreement, because it's against national treatment both. And interestingly, the US did not challenge this is against human rights. The US did not raise any issues, okay, this is a censorship and then you should not do this under the WTO law. What US really argues is that you can censor whatever you want, but in the WTO system manner. And this argument was accepted by the WTO tribunals. So the ruling is essentially saying that a WTO member, you can do whatever you need for the purpose of public moral to protect your local needs, your public interest. That's up to you. We defer to your decision. The caveat is you have to restrict these imports and the distribution in the WTO consistent manner. So what the WTO tribunal essentially says is that you have to give the trading rights to foreign companies and SOEs, and then do your censorships afterwards. So before the WTO ruling, the Chinese government actually give the power to the SOE and the dedicated power to censor the publications through SOE, because that's more convenient for the Chinese government. And that's one of the arguments that China made during the proceeding, that it's not really, it's too burdensome if we allow both foreign and SOEs to distribute, then we do the censorship afterwards. It's more time consuming and lots of procedures and transaction costs. But that is not a matter for the WTO tribunals. They believe you should treat them equal footing. That's your business. And they don't talk anything about free speech. And somewhere in the middle, if you recall that when Google was pulled out from the Chinese market, and there was a debate within the U.S. Policymakers and within the U.S. scholars, they tried to utilize that material again to bring down the censorship, the online censorship issue. But that's too political and too sensitive. So Google think that doesn't make sense. So it just pulled out their operation from mainland China, remove from their Chinese market to Hong Kong. However, some of the issues resurfaced again for the past 3 years also. That's it. If some of you, after today's presentation, make a comment on Twitter, say, Mr. Professor Liu make really awful presentation today on Twitter, can I actually ask Twitter to remove that? Because I think that's a defamation. I think that's not true. But that's a damage to my reputation. Can I require Facebook to remove that? And what if Facebook deny my request? Can I sue Facebook? Alternatively, if Facebook did honor my request, can you sue Facebook? Say that you infringe my freedom of speech. And what's the relevance to the WTO, to the international trade agreement? Very interesting case, as we see from the US, Canada, and Mexico agreement, and the US-Japan agreement since about 2018. The US has incorporated a new clause called interactive computer services. For most trade lawyers, when we first look at these provisions, especially the title of this clause, we have no idea what it is. What is interactive computer service? And when we look at the provisions, likewise, we have no idea what's the purpose. This provision essentially says that the parties recognize the importance of promotion of interactive computer service and for the purpose of digital trade, to promote digital trade. And then they agree that none of us should impose the liabilities onto interactive computer service suppliers. The liability as an information content provider. And the next clause also talk about they talk about that no party should also impose liabilities on supplier or users of interactive computer service on the account of any action voluntarily taken in good faith by the suppliers. So when you look at these provisions, what do you think of? What's the purpose of this provision? It's good for Facebook or not. That's going back to the scenario I just mentioned. Under these provisions, can Facebook be held liable if I sue Facebook? The answer is no. The trade agreements loosely define the interactive computer service as any systems or service that provides or enables electronic access by multiple users to a computer server. And those two subsections, actually, we can divide the concept as both a shield and a sword, in the sense that in the case that I just mentioned, if Facebook refuse my request and do nothing, I could not sue Facebook. Alternatively, if Facebook intervened and removed the statement, the Facebook has no liabilities either. So either way, Facebook is perfectly protected under this provision. So up until this point, you will realize that these provisions are really good for like big platform companies based in the US, right? So they will help them minimize their operational and the legal risks when they are outside of the US. But what is not covered under this provision is that when it comes to IPR infringement, these provisions does not apply, and it does not apply to like criminal law issues or other like public law issues. For IPR immunity issues, the reason why this has been carved out is the US has already exported its DMCA, like digital millennia, and forget the full name. It's about copyright infringements in the online setting by Section 512. US has already exported that domestic law through trade negotiation back about 10 years ago. And if we do a little bit comparison between those provisions and the US Communications Decency Act, Section 230, you will realize that it's pretty much a copy and paste from the US law. And the tricky thing is that US tried to downplay the controversial nature of these clause by using a non-hard title like interactive computer service. So no one will be caught that you will not really know what it's about unless you do a little bit of research into US law. And it's actually, if we look at the history and those case law and the controversies around CDA and Section 230, you realize that it's far more than trade. It's not just about trade. It's actually touched upon lots of free speech issues. And so let's talk about what is Section 230 and why US tried to incorporate CDA 230. In my research, I argue that US tried to frame these interactive computer service as a trade issue, which I don't believe so. Because if we look at the purpose of this provision, the CDA 230, it's not just about business. It's also about free speech. And they made that clear in Section 230. By contrast, in trade agreements, US framed these issues as a trade issue, as a purely economic affair, which is totally wrong. And Section 230 was adopted in the US under the Clinton administration, and it was passed in the background when the internet was just about to start. Some of the famous scholars like Jack Balkin, they talk about these provisions, Section 230, saying that if we did not have this provision in place back in about 20 years ago, we will not be able to have Facebook, Twitter's, Google's, these tech giants, because they provide a very broad immunity for these tech companies to grow up. And the CDA 230 is a provision that could resolve the so-called moderator's dilemma. So under traditional common law, whether or not your tort liabilities will be established will be, but in large part, depend on if you have knowledge about the defamation content, or you have reason to know this is a diplomatic statement. Right. And some of the famous cases before Section 230 was passed is that in one case, the platform did nothing. And the court said that because you are passive, you did nothing, not even try to moderate. So you have no knowledge. So no torts liabilities will be established. So the claimant was rejected. In another case, it's very ironically that the platform tried to do something good by remove some controversial content, and then it was called by the court that since you have tried to moderate, you have knowledge about the harmful content, and therefore the torts liability was established. So either way, you either take a hands-off approach, doing nothing, or once you moderate and you have the legal risk. So it's quite challenging for these platforms, these intermediaries, and then to resolve this moderator's dilemma, the US Congress have come up with a solution, which is Section 230 of CDA. And so what's the implications for those trading partners, including Canada, Mexico, and Japan, since they have already accepted these provisions in the trade agreements? Japan is very clever by pretty much cancel out all the effects that CDA 230 might have through a slide later, which I'll explain later. And Mexico likewise imposed a condition through the annex. The only exception is Canada, which made no qualifications and accept whatever the US required. Now first, look at Japan. In the slide later, Japan made it clear that both parties, i.e. US and Japan, we both agree that the existing Japanese law is not inconsistent with what we have agreed through interactive community service. So no change are needed, even though we entered a new agreement. However, if we do a little bit research into Japanese law, it's taking a totally different model. It's a notice and take down. If you have knowledge about diplomatic content and then you do nothing, under the Japanese law, you are not entitled to the immunity. So it's different from Section 230, but US and Japan agree that nothing has to be changed. So Japan has actually excluded the effect through this slide later. And the most interesting case is Mexico. First, the US has given Mexico 3-year grace period that you can gradually transition to accept this. But on top of that, Mexico made another application saying that we will only comply with our obligations to the extent that it complies with our constitutional law, Article 6 and Article 7, which is freedom of speech. So which means if I don't think the Section 230 type of language is consistent with our constitutional law, no, sorry, we could not be challenged. And the interesting case is Canadian approach. They have imposed and have no complications. And I look at the literature written by leading Canadian tech law scholars. some of them really welcome this Section 230 type of language. They think that's a new momentum that Canadian government can use that to reform the traditional English approach to intermediary liabilities. And in doing so, they can relax the burden to these social media platforms so that Canadians can get more opportunities to compete with Americans to attract tech companies to Canada. So that's the way of thinking, and that's one of the explanations why Canadians they have made no applications. And in fact, lots of proposals are going on in Canada. They try to reform and make the traditional English common law to defamation liability to rebalance the traditional common law approach. And until now, some of you may be puzzled, and I asked the question myself as well, based on our understanding of Americans, if they really want to have something in place, you pretty much have no leeway. Of course, that depending on your bargaining power. But why the US easily back down, allowing Japan and Mexico to have your publications that cancel lots of effects the US really wants? But if US really want to entrench their company's operation and business overseas, then they should have insist no publications or minimize your publications. But that's not the case. It's not as effective as it appears to be if we read into these side lectures and annex. So why? As I explained in the research, I think my guess is that the real audience is not so much about the overseas, the foreign trading partners. The more likely is that by way of embedding existing a controversial law in the trade agreements, some of the US policymakers, they try to tie their hands and lock themselves into the existing legal framework. Because there are lots of debates and the proposals, they are trying to bring reforms to Section 230, especially under the Trump administration. They, like both parties, they don't like Section 230 for different reasons. Like for Democrats and for Republicans, they both hate Section 230. Like for Democrats, for instance, they think they are too much hate speech, extremism. So we must regulate these big platforms. For Republicans, like when Trump lose the presidential election a few years back, then what they dislike this platform is not so much about hate speech. It's about they are mute by these platforms. Like Donald Trump's Twitter account and Facebook accounts were suspended by Facebook and Twitter, right? So they both want to have some sort of reforms. None of these reform proposals, I think based on my rough calculations early this year, there are more than 20 proposals have been reached any consensus between two parties. So it's smart for tech companies if we can embed this border immunity clause through trade negotiation, then it will be harder for lawmakers going forward, if you want to engage any reforms, you have to think about, well, what about those trade negotiations? Those deals we have already made, then we have to, before we can reform, then we have to talk about these issues with our trading partners. So it's a lock-in theory that will apply to this scenario. And it's not just about US, Canada, Mexico, and Japan. The US has tried to promote similar provisions through trade negotiation with United Kingdom, through trade negotiation with Kenya. And even thinking about promote similar ideas within the WTO framework. However, under Biden administration, this practice has been suspended. The reason being that if we really want to have a serious talk about how we reform Section 230, it's better not to export anymore. So they stopped the practice for a while. So I think some of the big takeaways we can see from what I have taught is that there are some boundaries we can identify for the US to diffuse its domestic law. Internally, domestic politics, especially like the politics about the hate speech and extremism and the different perspective between the two parties make it very difficult for the US even internally to reach a consensus about where to go. And before US can clarify their future directions, I don't think US would keep doing that by exporting Section 230. And that has been confirmed in the Biden's most recent practice. And externally, I don't think that other countries, especially other major jurisdictions, like EU, China, for instance, will accept such provisions through trade negotiation. They will pretty much push back. It's just incompatible with others' regulatory approach. Like in EU, the Digital Service Act, DSA, they also have the notice and take down model. It's different from Section 230. And likewise, as I understand from the Chinese Civil Code, it's similar, a notice and take down model under the torts provisions. And because the incompatibility in the UK context, some scholars from Oxford, they have urged the British government through submission that this is incompatible with the traditional common law approach. And especially when the UK it has passed the Online Safety Act. It's incompatible with the UK approach. And it's not just about the incompatibility, it's not just about civil liability. It's a matter of constitutional value. Because if you look at Section 230, it's actually American rule and tied closely with the First Amendment rights. And the US has been upholding their free speech above other competing values. And they love the idea of a marketplace of ideas. It's good to have debate so that we can search for the truth. That's the best way to exchange ideas. So that's the American thing, but that's not, the same judgment call is not shared with other liberal democracies, actually. If we look at European Union, and even if we look at the same common law jurisdictions. And So my current project is, I've finished the first project about the implication for Canada, Japan, and Mexico. I'm now doing more regime interactions by looking at if UK is thinking about these provisions, how incompatible, what are the implications for the United Kingdom? And the next project is looking at, it's really a good idea to address the free speech issue through free trade agreement, or it's better to just leave that outside of the trade regimes. It's better for human rights lawyers to talk about the issue. And I don't think it's a good idea to overburden the already big enough and lots of troubles already embedded within the trade negotiation within the WTO. And it's better to keep it simple so that we can move forward. It's interesting that traditionally, when we talk about e-commerce in the WTO context, they are talking about paperless trading. They talk about electronic signature. But with Americans get involved, they start talking about free data flow, no data localization, source code, encryption technologies, etc. They have gone far beyond than what we traditionally understand as trade issues by touching on lots of issues that not necessarily should be framed as a purely trade matter. And maybe just some final words. It's my preliminary findings about the UK-US divide. It's UK-US comparison is an interesting study because before 1960s, the UK-US pretty much adapt a similar traditional common law approach to defamation liabilities. We will look at your knowledge or whether or not you have a reason to know such a defamation. But after that, some of the case law, and especially some of the case law are influenced by the First Amendment rights. And with the passage of Section 230, the two common law jurisdictions have taken quite different paths, with UK being more pro reputation privacy, and the US is very or extremely friendly to free speech. You can see the common law divide between the two nations. And it's not just about civil liabilities, it's actually reflecting its deep ideologies and the constitutional values in both sides of the Atlantic. And there are lots of interesting things. If you are a private international lawyer, or if you've done a bit of tort law, you will see lots of American celebrities. They went to the UK and sued like Google's and other intermediaries because UK courts, they have a quite expensive jurisdiction. They can easily find jurisdictions to hear the case, and they are more pro reputation. So it's quite easy to establish the tort liabilities in the Britain. And when they win the case, they will bring back to the US and to enforce the judgment. And the US has been very concerned about these foreign shopping issues. Because back then, the UK, especially London, has the name of the capital of libel. If you want to sue, it's better to go to London. Then the US passed a new law called back in about 10 years ago, more than 10 years ago, which is the Speech Act, which essentially talks about foreign judgments will not be recognized and enforced in the US if it violates our constitution. What they had in mind is just exactly this libel tourism. they don't want the UK court if their judgments are not consistent with the First Amendment right. And you can see a bit of interaction. The UK, and then UK, after this Speech Act, they amend their Defamation Act again to say that, to make it more difficult to establish the tort liabilities, because they want to save the face. Otherwise, the British judges, their judgments will not be recognized and enforced in the UK, in the United States. So you can see the interaction between two sides of the Atlantic, and now US is again trying to exporting their First Amendment rights and free speech through international trade agreement. And that is again pushed back by UK scholars and policymakers. Okay. I think I could start with this. Some of the trade scholars, they also agree that it's not a good idea to protect free speech through international trade law, and it's better to live outside of the global trading system. Okay. I think I can stop here, and then we can have a bit of conversation. Thank you very much.
Thank you, Professor Liu. We have about 50 minutes for Q&A. Can I ask whether you have any question? Yes, Wendy.
So I'm really curious about when the normification of Section 230 starts. Is it? I'm thinking about is it influenced from the EU's data regulation, like for example GDPR, that force the US tech companies that they want to use another way to fight against the EU model? Would that be possible for a motivation?
Thank you very much. I think that's as a conspiracy theories believer, I also believe that's one of the reasons. The US, as you say, the EU has been promoting the EU law through the process effect, through their collective powers and the unilateral measures to affect other jurisdictions. And the US, because they get trouble to even have a consensus about data protection at home. So that's one reason I think the US try to promote their domestic way of regulation. And if you look at the free data flow and the no data localizations requirements as include in the most recent, it's pretty much a mainstream default norms in the trade agreements now. And that's actually the US trying to make that as a new global norm, that data flow should be a default setting, unless you have a justification to protect. Of course, we have a balancing act. You can protect your privacy data protection, but as a principle, we recognize it's important, but no data localization, please. And you have to justify why you impose data localization. I think they shift the burden to the regulatory state. You have to explain why you impose this. It's not the other way around. So I think this exactly the same way of thinking also reflects in this Section 230. The US big tech companies, they lobby exporting these US laws. But I tried to find out the relevant evidence supporting that. I could not find a very concrete piece of evidence. The only evidence is that the speaker woman, Nancy Pelosi, and she said that after this being export through trade negotiation, she said that I came too late. I could not stop it, and we should have stopped it. And I'm not sure how much truth she was talking about, but she lamented the exploitation of this law. Yeah, after this being embedded through trade negotiation. Yeah.
follow up on this question, can I also ask about the recent EU AI Act? Because you're talking about US setting this international norm, but on the other hand, that EU is also doing that too. And the AI Act, which is still in a preliminary draft, but at least they have agreed, they have specific reference that this will be the standard for investment, data protection, and also for content regulation. So how do you see it? Is it the other way around, that they are exporting the EU standard to the world? And I'm not sure whether back to your initial theme saying that back to harmonization.
Yeah. Thank you. This is, I think they are, US and the EU, they are competing with how and through what channels we can actually leverage our power, and which forum is the best place that we can actually influence other countries' regulatory approaches. And for US, the best approach is through trade negotiations. If you want to do trade, then you have to, I have the leverage to detect what you should and you should not do. So for data protection, for instance, the US has been focusing on more a soft law approach. Like talk about, we should look at like OECD guidelines, we should talk about the APEC, they have a CPPR, and talk about the individual companies' accountability, instead of using a country-based all or nothing type of like data flow. And so the US has been using the trade negotiation, and the EU is a bit of, in the EU trade agreements, initially EU is a bit of hesitant to talk about free data flow because of their GDPR. And they also have their wide list, like which countries can receive the data from EU. So they have gradually shifted their position. They are more willing to talk about free data flow with some trading partners step by step, but with a lot of qualifications, not as liberal as Americans. But agree, I see the trend that they both major powers, they try to influence the global norms through different ways. And that's why, like Andrew Bradford, they talk about in the digital empires, the US may lose if US did not take this regulation seriously at home. And if US fail to cooperate with EU and other like-minded democracies, they may fail. And they may fail to the different regulatory model, which is China. China has been quite on the defensive side. If you look at the bigger picture, in the trade agreements, China is quite reluctant to talk about data localization and that kind of issues. And the reason why I don't really like these data governance issues to be embedded in the trade agreement is that I feel international trade lawyers, we take for granted like a convergence, harmonization is a good thing. And just give you one concrete example. I had a conversation with law enforcement back in Taiwan and law enforcement authorities. Some of them are very serious about to propose data localization measures back a few years ago because Taiwan has no mutual judicial assistance mechanisms in place. And it's quite challenging for Taiwan police officers and prosecutors when some of the data are stored overseas, especially in Japan. Like lots of the Taiwanese users, they are using Line, not WeChat or WhatsApp. and the line, their data center is in Japan, and we had no collaboration agreement. So if you want to investigate a criminal cases, then there is no way you can get data. So there is a need for data localization measures, at least for some jurisdictions. But the US has reshaped the default norm through trade negotiation that no, sorry, unless you have justifications. So I think it's not a good idea. And these concerns has been, I think, has been shared by at least some international trade lawyers. They think about we should think how far international trade law should go, and we should stop and not to overburden the international trade regime.
Any question? Yes.
With reference to your point on CDA and like the US trade law harmonization, right? So you mentioned that Mexico and Japan are some of the countries that suggested qualifications or amendments to what the US proposed. So I would like to understand the hindrances it would have on international trade if most countries were to suggest qualifications and amendments, right? Because US is trying to sort of enforce their opinion through this. So how would trade be affected overall if every other country that they're trying to negotiate or establish trade with has some sort of qualification, or they want the US rules to be consistent with their own legislation? So what sort of challenges do you think we would face with establishing trade with the US?
I think, thank you very much. This is good questions because US, in the trade agreements, you can see there are actually two contexts. First, the best way for the US to export this regime is through WTO. It's multilateral, done once for all. So every country has to accept whether or not you like it. And that's the most convenient way. But in the previous version that the US tried to propose, US is the only WTO member endorse this agreement, this provision. None of other WTO members agree this is a good idea. And alternatively, US can export this law through bilateral context. It's easier for US because it has an overwhelming leverage power. I can detect, for instance, that with Singapore or with other smaller economies, they have much better position to talk about this. And that is exactly why I don't really understand US will allow Japan and Mexico to have so many carve-outs. That means the US is not so serious to export Section 230 for now. So their real audience is their domestic stakeholders. It's about bipartisan politics. Right? They are fighting against each other.
Thank you.
Thank you.
Any other questions or comments?
So I'm just wondering, because I'm studying Global South, so particularly as you may know that in the Global South, people always care about, digital sovereignty or something. That's reason most Global South countries introduce a data localization system very firmly. So what's your comment about this approach? Just because it seems that US is always negotiating trade agreements with northern countries. But what if you would like to negotiate a trade agreement with those Global South countries?
Yeah, thank you. It's interesting that when we talk about global north and south, and because when we think about north and south divide, then we are talking about mostly like developing countries. But sometimes we would also talk about in some of the international economic law literatures, even Australia as well, they find themselves as global south. I think it's a good idea to distinguish more like rule takers and rule makers. So lots of the global norms are now emerging through either the unilateral or collective powers like EU or through international trade agreement, like as detected by US. So as I totally agree that for most developing countries, Singaporeans always use the terms like price takers. They don't talk about rule takers, they use price takers because we are paying the price to reshift our domestic law to align ourselves with developed countries, either EU or US. So how can we cope with this, the transaction cost? I think that's one reason I against, as an international trade scholars, I'm against this type of globalization and harmonization. I think we should defer more to regulatory state. I'm not against the global trade per se, but I'm against the way that we should harmonize. We should give more regulatory powers back to each state. And it's not just about the rule-taking issue. It's also about capacity building. I had a chance to work with Asia Development Bank about cybersecurity and the digital trade issues. And when I look at the Southeast Asia, ASEAN countries, the issue is not so much about whether or not we should protect cybersecurity. It's about we don't even have the capacity. So if you read the capacity, cybersecurity provisions, when it comes to these Southeast Asian countries, they are talking more about capacity building. Yeah, like Australia and Singapore, they have signed lots of MOUs with Southeast Asian countries to help to build up capacities when it comes to cybersecurity before they can really make sense of the sum of these provisions. Yeah. Thank you.
Thank you. Because of the time, I'm afraid we have to end here, but I'm sure that Professor Lee will be happy to stay behind to have a chat with us in case you have any questions or comments. For now, I would like to join hands to give a big thank you to Professor.
Thank you very much. Thank you.